Hello everyone, and welcome to our videocast on civil procedure and trial practice as it applies to healthcare management. For many of you, this may be your only formal introduction to the legal aspects of healthcare. So it's important to understand not just the law itself, but how that law unfolds in the courtroom. This chapter will help you grasp the essential procedures leading up to and during a trial. Procedures that differ based on each state's statutory requirements and at the federal level by federal statutory requirements. By understanding how civil procedures work and how trial practice is organized, you'll be better prepared to navigate legal challenges you might encounter in your healthcare career. Let's explore these critical concepts together. Enjoy the videocast. The goals of this module are to guide students in exploring the pre-trial discovery process, which involves the exchange of evidence and information between parties, the trial process, which outlines how cases are presented and judged, the forms of evidence the plaintiff may present, including direct, demonstrative, documentary, or expert testimony, the defenses the defendant may offer to refute liability, the judge's charge to the jury, which instructs jurors on the relevant law to guide deliberations, and the various types of damages such as compensatory, punitive, and nominal, along with the awarding criteria so that students gain a comprehensive understanding of the fundamental legal procedures and concepts within the civil justice system. So, the pleadings are written statements of fact and law filed by the parties to a lawsuit defining the issues for the court to decide. They generally include a summons and complaint by which the plaintiff initiates the lawsuit against the defendant and can also involve a demurrer, answer, counterclaim, bill of particulars, or pre-answer motions to dismiss the complaint. The summons and complaint outline the plaintiff's allegations, while the answer or demurrer allow the defendant to respond or challenge legal sufficiency. A counterclaim asserts the defendant's own claims, and a bill of particulars clarifies allegations. Through these pleadings, courts and all parties gain a clear understanding of the dispute at hand. Summons is a formal legal document typically issued by a court and served on an individual, signifying that a lawsuit or legal action has begun. This notice outlines the date and place the defendant must appear to address and respond to the complaint's allegations. In some jurisdictions, the complaint, a detailed statement of the plaintiff's grievances, must accompany the summons when served. The summons is crucial in ensuring due process as it allows the defendant an opportunity to prepare a defense. Failure to comply might result in a default judgment, underscoring the importance of adhering to the summons instructions and meet deadlines. The complaint is the first pleading in a lawsuit filed by the plaintiffs to initiate legal action. It lays out the relevant factual allegations supporting one or more causes of action, essentially describing how the defendant's conduct gave rise to the lawsuit. The complaint also specifies the relief or damages the plaintiff seeks, such as monetary compensation or other remedies. By formally outlining the factual basis for the claim and the damages requested, the complaint serves as the foundational document that informs both the defendant and the court of the nature of the dispute and what the plaintiff aims to achieve. So we can see in this slide the term demurrer. A demurrer is a pleading, often filed by the defendant, arguing that even if the plaintiff's allegations are true, the complaint does not present a valid legal basis for the lawsuit. Essentially, it challenges the legal sufficiency of the complaint, contending that the evidence or facts stated do not support moving forward with the case. If the court grants a demurrer, the plaintiff may have an opportunity to amend the complaint to address the deficiencies, or the case could be dismissed if the flaws cannot be corrected. When responding to a complaint, The defendant typically files a formal answer addressing each allegation and may assert specific defenses or affirmative defenses. Such defenses can include alleging that the statute of limitations has expired, that the plaintiff was contributory negligent, that the underlying obligation has already been satisfied, or that a general release was granted. The defendant might also claim that the contract in question was illegal and therefore null and void. Additionally, the defendant must confirm the action is initiated in a court of proper jurisdiction and provide a copy of the answer to the plaintiff's attorney, thereby setting forth the grounds upon which the defense will rely. A counterclaim is a claim asserted by the defendant, typically included with the answer, which not only denies the plaintiff's allegations, but also seeks affirmative relief against the plaintiff based on related facts or a separate cause of action. In contrast, a bill of particulars is a formal request for a detailed written breakdown of the claims asserted, such as the specific date and time of the alleged negligence, the location where malpractice and injury purportedly took place, the nature of the negligent act, the manner in which the negligence supposedly occurred, any injuries claimed, and the witnesses who may testify to the malpractice. The discovery phase is the pretrial process in which parties investigate the facts of a case, ensuring each side has the right to examine witnesses and evidence before trial. By securing documents, depositions, and other information that may otherwise be unavailable during trial, the parties can isolate and narrow the issues to be litigated. Discovery also enables counsel to learn about additional evidence that could be admissible, granting crucial leads to gather further proof. Overall, this procedure ensures fairness by allowing both sides to prepare their arguments thoroughly, helping prevent surprises, and promoting an efficient resolution of the dispute. An important concept is the attorney-client privilege concept. ASI ensures that confidential communications between a client and their attorney remain protected from disclosure in legal proceedings. In healthcare management, this privilege is especially important when seeking legal advice on sensitive matters, such as patient privacy, regulatory compliance, or liability concerns, since both parties must agree that an attorney-client relationship exists or will exist. The client must specifically engage the attorney in the capacity of a legal advisor, and the communication must be clearly identified as confidential. By preserving the confidentiality of these discussions, healthcare managers can obtain candid legal guidance without fear that sensitive information will be exposed. Incident reports are internal records documenting adverse events or near misses, typically used to improve patient safety within healthcare facilities. However, these reports are generally not protected under attorney-client privilege or other confidentiality doctrines, meaning they can be subject to discovery in litigation. Similarly, statistical data such as quality metrics is not always privileged and may be disclosed to opposing parties if it is relevant. In Braverman v. Columbia Hospital in Gomez, for example, the court examined how certain data and analysis could be discoverable. Consequently, healthcare managers must recognize that routine reports and data might become evidence in legal proceedings if not otherwise protected. An examination before trial, often called a deposition, is a discovery technique where a witness's testimony is recorded in a written form before the court date. It allows each party to gain insight into the substance of the opposing side's claims or defenses, helping clarify key facts and issues. Preparing a witness for this questioning is critical. How a witness conducts themselves during testimony can be just as influential as the facts they present. Effective preparation involves reviewing all relevant documents, understanding the potential scope of inquiry, and practicing clear, concise responses to ensure accurate and confident testimony in a legal proceeding. Preparation of witnesses is a crucial aspect of any legal proceeding, and the next 2 slides offer practical guidelines to ensure effective testimony. Witnesses should review all relevant records and come organized in both thinking and recollection of facts. They must remain calm and avoid antagonism, answering only the questions posed and doing so simply and succinctly. Over-dramatizing or allowing a cross-examiner to dominate should be avoided. Politeness, sincerity, and courteousness go a long way, as does dressing and grooming appropriately. Witnesses should listen for objections, review their deposition, examination before trial beforehand, and be honest if unsure of an answer. If clarity is needed, they can request for a question to be repeated, and any further elaboration can be provided during redirect examination by the attorney. A pre-trial conference may be ordered by the judge or requested by the parties themselves to clarify what the actual disputes are, streamline any procedural matters, and determine whether the case can be resolved without proceeding to a full trial. During this stage, the parties can agree on issues, eliminate those not genuinely contested, and even reach a settlement outside the courtroom if they choose. Once a decision is made to move forward, a notice of trial is issued, placing the case on the court schedule. This ensures both sides know when and where the trial will occur. A memorandum of law is a written legal document submitted to the court, outlining the nature of the case and citing relevant statutes or case precedents to support each party's arguments. It clarifies key issues, aids the court in understanding various points of law, and can be prepared by both the plaintiffs and the defendant's attorneys. Although not required in every circumstance, filing a well-developed memorandum of law is considered a prudent strategy, as it offers the judge crucial guidance on the legal framework of the case and helps streamline the trial process. Within the courtroom, the judge, representing the court, oversees the entire trial process, ensuring proper conduct and applying the relevant legal principles. The judge resolves questions of law and procedural matters, ruling on the admissibility of evidence. Once both sides have presented their cases, the judge may charge the jury, providing legal instructions that guide the jury's deliberations and determination of the facts. In certain instances, such as when evidence overwhelmingly supports one party, the judge may direct a verdict, effectively deciding the outcome without sending the case to the jury. A jury is a group of individuals chosen from a pool of eligible citizens and summoned by a document known as the jury process. During the jury selection stage, attorneys for both the plaintiff and defendant engage in voir dire, questioning prospective jurors to uncover any biases or prejudicial attitudes that could affect their impartiality. If a defendant so chooses, they may waive their right to a jury trial, opting instead for a bench trial where the judge alone decides the case. However, in most instances, a properly selected and impartial jury is critical to ensuring a fair trial process. A subpoena is a formal legal command compelling an individual or organization to either appear in court or an administrative proceeding and/or produce specified documents. There are 2 primary types: subpoena ad testificandum, which requires a witness to provide in-person testimony; subpoena duces tecum, which directs someone to bring certain records, documents, or other tangible evidence. Failure to comply with a valid subpoena can lead to penalties such as fines or contempt of court, making it a powerful tool in the discovery process and at trial. In civil cases, the burden of proof rests with the plaintiff, who must convince the jury that the facts of the case support their claims. To succeed, the plaintiff must present a preponderance of credible evidence, meaning the proof offered should indicate that the plaintiff's assertions are more likely true than not. Credible evidence is that which appears under reason and common sense to be believable and reliable. Without meeting this standard of evidence, the plaintiff cannot recover damages, as the jury must be persuaded the claim is sufficiently substantiated by the weight of the evidence presented. Res ipsa loquitur is a legal doctrine meaning the thing speaks for itself, which shifts the burden of proof from the plaintiff to the defendant in cases where an injury would not ordinarily occur without negligence. Common examples include scenarios such as aspiration of a dental crown, patient burns during a bath, electrocautery-related burns, or an oxygen mask catching fire. In these situations, once the plaintiff establishes the event's unusual nature, it becomes the defendant's responsibility to explain or disprove any negligence, acknowledging that under normal circumstances, such incidents would not happen without someone acting carelessly. Under res ipsa loquitur, the plaintiff must establish three key elements for the doctrine to apply. The event causing injury is of a nature that would not typically happen without negligence. The defendant maintained exclusive control over the instrument or situation that caused the injury. The plaintiff didn't contribute to the circumstances that led to the harm. If these conditions are met, the law presumes negligence, shifting the burden to the defendant to explain or rebut how the injury occurred without fault on their part. Now let's analyze the case of the oxygen mask that catches fire. During a surgical procedure, an oxygen mask unexpectedly caught fire while the physician operated an electrocautery unit in close proximity to an oxygen source. Although this might seem like a highly improbable mishap, it became central to a legal dispute when the injured patient argued that the very occurrence of the fire signified negligence on the part of the medical team. Oxygen is inherently flammable, so using a spark-generating instrument near it poses a known risk. Because the patient had no role in controlling or contributing to the accident, courts ultimately recognized that under normal circumstances, such a fire would not occur absent negligence. Opening statements set the stage for the trial by allowing both sides to outline their version of the facts and what they intend to prove. The plaintiff's attorney typically begins presenting an overview of the events leading to the lawsuit, the evidence that will support the claim, and the damages the plaintiff seeks to recover. This gives the jury, or judge in a bench trial, a clear sense of what the plaintiff believes happened and what they aim to establish with testimony and exhibits. The defense attorney then follows, providing the defense's perspective on the facts, explaining how they will refute the plaintiff's allegations, and presenting reasons why the plaintiff is not entitled to the requested damages. Once opening statements conclude, the court proceeds to the examination of witnesses, typically starting with those called by the plaintiff. For instance, if the witness is a physician, preliminary inquiries often establish their professional background, such as where they attended medical school, whether they hold a valid license in the state, and where they served their residency. The witness is then asked to describe the treatment they rendered, establishing the foundation of the testimony. This initial questioning sets the stage for more detailed exploration of facts and potential cross-examination by the opposing counsel, who aims to clarify or challenge the witness's statements. Judicial notice permits a court to recognize certain commonly known or undisputed facts as true without the need for formal proof or expert testimony. For example, it is widely accepted that fractures require prompt medical attention or that x-rays of the same patient can yield different results. These are facts so well known and self-evident that requiring additional evidence would be unnecessary. By taking judicial notice of such matters, the court can streamline proceedings, focusing instead on contested issues where proof is genuinely needed.